morning, everybody. Lovely to be with you on day 2. My name's Anna Pienaar, as Neil mentioned. I am with the UN Migration Agency, IOM. I was previously Executive Director of the Responsible Labour Initiative with RBA. My role now focuses on some of the challenges that we were talking about yesterday, where there is a need for workers but insufficient legal pathways, regulated pathways. So I'm doing part business and human rights work, and then also really working with governments in the private sector to identify where are those needs and where can IOM facilitate those regulated pathways. So it's lovely to be with you all, and I'm going to ask my panelists to introduce themselves. Ray, would you like to go first?
Thank you. Good morning, everyone. My name's Lindsay. I'm a partner here at Clifford Chance, and on behalf of the firm, we're absolutely delighted to be hosting the forum. I'm the co-head of our business and human rights practice, so I work with companies in a variety of areas in relation to historically implementing the UN guiding principles in the OECD guidelines, human rights due diligence, and so on. But I'm also very honoured to have had a long-standing association with the Institute for Human Rights and Business, where I'm a member of the International Advisory Council and was formerly the co-chair of trustees. Amazing organisation, which is why we really value that association and all the incredible work the Institute does. So delighted to be here.
Thank you, Ray. Maria Isabel.
Thank you, Anna. I'm really pleased to be here with you in this all-women panel, at least in person. Maria Isabel Cubides. I work at the Consumer Goods Forum, where I lead the Human Rights Coalition, which is a dynamic collective of 26 companies working to make human rights due diligence the industry norm in their own operations and supply chain, and also connecting the people and planet agendas. I'm a lawyer by training in Paris, based in Paris, and also originally from Colombia, where I also practice law, and I've been in the field of business and human rights, initially in the civil society perspective, so giving my members a bit of a hard time sometimes, and then came on to CGF to keep on learning in this very complex and interesting field of work.
Thank you so much. Hi, Bart, good to see you. Would you like to introduce yourself? Wait 1 second. Okay, go ahead.
Good morning, everyone, and good morning, Anna. It's a pleasure to join you. It saddens me that it has to be here online. I really wish I could be there in London, but that's what it is for now. So my name is Bart Devos. I'm Vice President of Public Policy at the Responsible Business Alliance. Most of you probably know the Responsible Business Alliance as the biggest worldwide industry alliance focused on supply chain sustainability. So our core mission is to help companies drive more responsible supply chains, and my specific role is to make sure we do that in close collaboration with governments around the world. And that in doing so, we try to align as much as possible with emerging regulations, including in the forced labor space. So I'm very excited to talk to you a bit later in this panel about our vision on how laws can drive the goals that we all stand for at this event today.
Great, thank you, Bart. So this panel is really focused on the hot topic of the day, which is regulation. And we're going to be discussing, sort of debating whether or not the regulation is pushing further collaboration or whether there are challenges related to that. Just some quick reflections on day 1. We talked quite a bit about collaboration. We looked at the panel on Asia, talked about the role of increasing leverage and sort of working with governments, businesses working together to engage governments, but then also asked the question as to whether or not the competition for investment in some countries in Asia is going to actually lead to potential issues related to, are there going to be labor rights protected and built into that, or is there going to be a drive to attract investment, and is that a tension that we need to be aware of? There was also some good examples about specific cases related to joint remediation, and how collaborating also with sending and receiving governments can be a good way of ensuring that labor rights are built into those corridors and those recruitment practices. So we hope to really continue the debate today. And I'm going to start by asking just a broad question about where we are now related to collaboration with government, between private sector and government. And so, Maria Isabel, can you tell us some practical examples about how your organization is currently working with governments?
Sure. I want to talk about an example that really speaks to where we are today compared to where we were in 2019. so a few years ago. And this is a story about Malaysia. Malaysia was a country that was for the last time ranked as tier 2 in the TIP report in 2017. Things were downhill from Malaysia since then. 2019, companies are hit with WROs, and up to today we have 6 companies that were subject to CBP WROs, and these were millions, if not billions, of costs for both buyers and suppliers in Malaysia. Companies paid over 40 millions to repay workers to improve their housing. You know, once the WROs hit Malaysia, companies got to work. They didn't deny the issues. They said humbly, okay, we're going to get to address these things. And so they started working themselves, but also together as industry groups or sectors. CGF launched what we call the People Positive Palm Project. And through this project, we train and build the capacity of suppliers, supported them individually in their journey to improve human rights due diligence systems, but also train and engage with recruitment agencies. And as we help companies navigate that journey or start improving in that journey on human rights due diligence and improving their responsible recruitment practices, we realized that our efforts were not enough to have a scale, an impact at scale. And this is where we started engaging with the Malaysian government, because we understood that they were a key piece in the puzzle for the change to happen at a sectoral level and for our ambition of forced labor being eradicated from the palm sector to be actually, truth. So we started engaging the government, and we brought some key messages. We realized in practice that responsible recruitment could improve, but as long as the licensing system of recruiters in Malaysia did not change, then change was not that sustainable and at scale. We also saw the capacity of the labor inspectorate being very weak, and so the need to improve institutional capacity. Recruitment fees still being legal to a certain extent did prevent companies going in the direction of eradicating recruitment fees to become less competitive, less with a higher cost to operate. And finally, while trying to end forced labor, we also look at the immigration permits for workers, and so the need to improve worker mobility. And so we started this very difficult conversation with the government in 2022. And just a few months into the conversation, the Deputy Prime Minister of Malaysia, for the first time in a public address, referred to human rights due diligence as a tool that could be an opportunity for the economy of Malaysia to improve resilience, to attract investments, and to make companies, leading example in the region. We're now 2 years later. The engagement has not been easy, especially in a country where governments change overnight. But yesterday, the TIP report was released, and Malaysia was upgraded to tier 2. Since 2017, they hadn't been tier 2. So the recognition that the address of the Ministry of Home Affairs yesterday was about, these is an acknowledgement that we are undertaking serious efforts to change the practices of business and the framework in which they operate. It doesn't mean that we have it all figured out. And he acknowledged, the work of those that have taken the hit economically, because they have taught the lessons to the broader group, but also the road ahead and the need for the government to build capacity, to start reviewing the legislations that are setting that environment so that it's more supportive of responsible business conduct, and to monitor and report, to have data about how we're doing in terms of responsible recruitment. So I think now we are in a place where governments are more aware of the value, but also the cost that doing responsible business may have for their economy and for their businesses. they're more aware of the need to collaborate in order to have positive achievements. And so since business have been doing this already for a while, have learned lessons, have already tools that are practical, have examples and pilots, they can bring these to the table so that together we can foster policies and regulatory environments that are informed and grounded in reality and really accelerate and scale that change towards human rights due diligence and responsible recruitment.
That's brilliant, thank you. And it's really highlighting that collaboration is not a nice to have, it's not an option. All of those actions you mentioned, licensing, regulation, labor inspectorates, monitoring and data, all of that requires government action, and it needs to also have the voice of the private sector engaged in that. So that's a really helpful example, thank you. Bart, can I ask you the same question about practical examples on working with governments?
Yeah, thank you, Anna. I'll try to not be duplicative, but there was a lot of interesting in what Maria already said. So for RBA, our collaboration with governments, I think it's the same, is very diverse, both in terms of the geographies that we cover, but also in terms of the nature of the work we do together. When talking about this, I should normally start with Malaysia, because it's one of the countries where we have had extensive programs through our labor initiative, working on focusing on capacity building around ethical recruitment, and in which indeed also the Malaysian government was a key stakeholder. But perhaps to diversify, I want to give a more recent example of the work we are doing in Japan with the Japanese government. So we recently entered into a formal collaboration. We signed an agreement on this with the Japanese government to support the development of responsible recruitment corridors feeding into Japan. And that's really a partnership where we practically are leveraging each other's trainings tools, each other's grievance mechanisms, potentially in the future also each other's standards, and looking at certification, to look at, like the joint industries that are represented inside the RBA, a lot of Japanese member companies, and in the Japanese economy that channel into Japan. How can we help them learn from the experiences we have in Malaysia and transfer that experience to other corridors? At the global level, what we're also doing is using our convening power, leveraging the collective influence we have as the organization that represents hundreds of the largest global companies, to advocate for more government collaboration, policy coherence in the forced labor space. Because one of the things that we found when we look back at, where have we performed well and not in the past 3 years, is that we clearly see that there's a lot of government industry collaboration that has gone next level, that we do have the willingness in place, that we do have increasingly the right platforms in place, but that there's still very little coherence between those different project spaces, different corridors, different jurisdictions, and that while on paper, most policymakers agree on the need for policy coherence and coherence in the way that governments work with industry, that in practice, we don't always have coherence between those efforts, practical solutions for coherence. And that's why earlier this year as RBA, we hosted a Global Forced Labor Summit that brought together, I think, between 15 and 20 global jurisdictions, both US, EU, Canada, regulating markets, and then also producing countries, Indonesia, Thailand, Vietnam, to talk about practical solutions for more coherence in those efforts. And what we see is that clearly the willingness is there, but it's now time to use the emerging regulations, things like the EU Forced Labor Regulation, CSDDD, UFLPA, to drive more practical solutions to how to bring it together more coherently.
The opportunity there for how to align, the challenges between these different jurisdictions, and sometimes that can be a challenge, but it's also an opportunity. Maria Isabel, can I quickly come back to you to just reflect on what do you think is working and not working related to these collaborations? Because as Bart mentioned, it's different by corridor, right? You really have to dig in, as you did in Malaysia, to really focus on, here's the challenges in this corridor, but there are many elsewhere. What's your reflection?
Yes, well, I think 3 things that worked and 3 things that are still a challenge. First one that worked, I think, engaging as a group. So CGF engaged as an industry group, and this gave us increased leverage, a different voice towards the government. And I'm not saying that CGF voice was the only one or the most legitimate, but it helped us drive that collective voice together, having both the global brands and retailers, and also the collaboration with the local suppliers and the voices of those businesses in Malaysia. The second thing, I think, was thinking about engagement, starting in Malaysia, but also going out to the country of origin where migrant workers are coming. So Indonesia is the #1 country sending workers to Malaysia, and we started in a dialogue also with Indonesia to understand first what are the issues that need to be addressed, for instance, in terms of recruitment fees when workers, or in the first half of the journey of workers that happens inside Indonesia, and then how can we also help them strengthen the message towards Malaysia and what needs to be done jointly. Secondly, the dialogue that we had was always informed by the experience of business who walked the talk. So it was not about we need this or that, just because, but we have an example. This is how it happened for Sime Darby, for FGV, for Top Clove. How could we prevent this from happening again, or how could we do better? And then third one is a challenging one, but still I think a win, is cross-ministerial dialogue. So it's true, when we talk about responsible recruitment, there's no one ministry, human resources, that can deal with it all. It's always a mix between home affairs, foreign affairs, and the thousands of ministries that keep changing names. So bringing everyone around the table, and bringing also the European Union, the Australian Embassy, the UK Embassy, the Japanese Embassy, because we are talking, so that we were not talking as the Europeans coming to bring a new standard yet again, but as something that the global landscape is changing, and this is how we can collaborate together. 3 challenges yet. One thing is preventing the backlash of what these new legislations can create. So that, proactive engagement and talk about human rights due diligence before CS3D comes into force, it helps us build that narrative towards a good implementation. Because unless we have the countries where the commodities are coming from on board in this implementation, it's very difficult for them to be effective. But that's the second challenge, is coming actually from the talk to the policy change. It's a long road, and we need to take the small wins, but we're really hoping that we can have a stronger push towards actual policy changes. And there's where I think many factors come in, and many actors need to come together, from civil society to government, around the table. And then finally, how do we navigate a landscape where, the attention or pressure that the WRO may bring at one point may also decrease pressure at another one? And how do we build that awareness and understanding that responsible recruitment is a must all the time, not only when the WRO has hit you, not only when CBP has the eyes on Malaysia, but all the time, because, and this is about something that we'll probably touch upon later, but is, how do we change the mindset, the business model? Because if we keep operating in the same way, we'll keep having the same issues. And this works both for government and for companies.
That's a fantastic segue into the question I have for you, Ray. So Maria Isabel was really highlighting the need for regulation to create that level playing field and structurally then have an impact, we hope, on actual business models that have been operating in one way for a long time, but legislation can create a more level playing field. So from a legal perspective, can you talk us through some of the many upcoming legislative changes and how you see that, from your perspective, either encouraging or discouraging collaboration between business and government?
Thanks, Anna. Big questions. You've obviously got different legislative approaches to addressing the forced labor issue, with the forced labor bans in the United States, for example, and the one that's about to come through in Europe. And then those bans intended, incidentally, to drive due diligence, because companies have to try to show that there is no forced labor in their value chains. It's been an interesting, I was a skeptic about whether forced labor bans would actually have any effect on workers on the ground, for example. But there have been some encouraging indications from what's happened with WROs in the United States. I don't practice there, but in those instances where they have occurred, they certainly seem to have incentivized some really quite in-depth due diligence and remediation to the extent of having to get rid of forced labour indicators in supply chains at some significant costs, as we've talked about, to companies which have then potentially become insolvent. So how do we balance these, the incentives and the repercussions and not create perverse outcomes? But certainly it seems to have been a driver for increased due diligence and also highlighting some of the limitations of what companies do with due diligence and some of the mechanisms that they rely upon. So bringing under the spotlight, as we all know, some of the limitations of social audits and third-party verification. And the fact that these are tools for companies and they have to be relied upon to an extent, but nothing ever replaces, including in the regulatory environment, the fact that each company is responsible for really knowing its own supply chain and what issues it has there and actually grappling with the issues. So the Corporate Sustainability Due Diligence Directive probably is going to make the biggest impact in terms of hopefully driving these different approaches to due diligence. I had some concern about how effectively a legislator could try and basically translate soft law standards like the UNGP and the OECD guidelines into a legal framework, and it remains to be seen how effectively it's done that. It's obviously not an exact mirror. As John Ruggie said, you can't just take this off the shelf and plug it in. But there are certainly features in the Corporate Sustainability Due Diligence Directive that it could succeed in really driving much more effective due diligence and on a global scale. Obviously, it's got scale back impact on the number of companies that are actually going to directly have to comply. And there have been concerns that it could become a tick box exercise. I think the regulation has done quite a lot to try and build in features that should not allow that to happen. So in order to conduct due diligence, which is obviously the objectives of due diligence, is to identify actual and potential adverse human rights impacts in your value chain, and then to prevent and mitigate harm, and then remediate actual harms that may occur. So the whole intention is obviously to ensure that prevention in the first instance, and then remediation if impacts can't be prevented. The definition of what is expected from companies involves the application of what are called appropriate measures in the conduct of due diligence, and the appropriate measures are identified by reference to their effectiveness in achieving the objectives of the due diligence, which is obviously these prevention, mitigation, remediation outcomes. So to that extent, to the extent that we're going to be looking at companies and whether what they're choosing to do is or is not, or could not be effective on an objective basis, that hopefully will prevent some of the tick box pure compliance approaches that we can expect. Built into the due diligence approaches are obviously a lot of features that we see in standard supply chain human rights risk management generally, so contractual assurances, codes of conduct, independent verification, etc. But again, these efforts to try to ensure that they are meeting these objectives, again, those have the possibility that they're going to take a lot of work. I think this is probably my main thing about the CSDDD. I'd like to be glass half full, but it's going to take masses of commitment, resource, and real effectiveness at all levels to really make it work. And that goes right through from the member states when they implement the directive international laws, to the Commission and the member states when they're creating tools for companies to try and help and support companies and stakeholders to deliver on the legislation. Then obviously companies themselves, with their lawyers and their compliance people hopefully playing a positive role, and how do we make that happen? And then getting together all these various bodies and sources and guidelines that are supposed to help companies along the way. So I think there's some huge challenges. In terms of collaborations, though, and collective leverage, again, specific requirements or expectations in the due diligence requirements, encouraging companies to collaborate at industry level and in multi-stakeholder initiatives right through the due diligence process, including with respect to identifying risks, tools on how to deal with those risks, and then through the notification and complaints procedures. Encouraging companies where appropriate to engage or utilize industry and multi-stakeholder initiative tools in their stakeholder engagement. And then as one of the expectations on companies when they're trying to prevent and mitigate and then deal with any impacts that have occurred. An expectation that where they aren't able to address an impact on their own, that they collaborate with other entities, undefined, in order to bring collective leverage to bear in order to achieve the objectives of due diligence. So I think the regulation does a good job in bringing in a lot of components that everyone would say are really important in achieving effective due diligence, including, I'll just add this before I forget it, but when we think about, it's one thing for big companies to be doing this, encouraging companies to go to where the most likely the impacts are actually occurring, to skip over where necessary their direct contractual relationships, to engage with entities further down their value chain, which I know companies do anyway, but encouraging that approach. And obviously, really, sorry, I've lost my train of thought, but really, as I say, trying to encourage the approaches that everyone says are needed to work, building them in as expectations, and this idea that there will be supporting guidance and tools at both member state and commission level, including commission being able to facilitate new multi-stakeholder initiatives and industry initiatives that will help achieve these purposes. So if the resources are put in at the commission member state level and then within companies, then you could see this filtering quite effectively through value chains.
In terms of what we were looking at yesterday, how do you see this? Because this is, all of these things are happening and they're going to impact, obviously, companies who are doing business in Europe, but there is going to be this significant wave of global impacts, isn't it? How do you see that affecting? And so, for instance, we were having a discussion on Asia yesterday and internal migration, a lot of focus on India, for instance. So how do you see that then? What should other countries and businesses operating in other countries that are supplying to companies that are going to be impacted by the EUCS-DDD, how do you see that rippling out across the world?
Well, obviously, and this is one of the concerns as to how this will work in practice, is you're obviously going to have a cascading of expectations, including, the company's code of conduct through its value chain. And so one of the concerns, as we've seen with other mandatory regimes in places like France and Germany, is what is there's actually really burdensome impacts on entities down the value chain who can't then comply or who are asked to confirm that they are complying when everyone has no realistic expectation that they will. So again, this comes back to the effectiveness, the expectation within the directive that companies will support SMEs in their value chain in order to build capacity, and that can include offering financial support to others in their value chain to do so, which obviously would play into the responsible recruitment space. This places a huge expectation on business, and so again, it's going to be about making sure that the responsibility allocation is consistent with the spirit and intent of the directive, and that the expectations are not so unrealistic that we do have the perverse outcomes, which is de-risking in the value chain, rather than actually feeling inclined to go and look for the issues and then be part of the source of remediating them, recognizing that a lot of it has to do with being aware of and sensitive to and working with suppliers and helping them deal with the challenges, rather than sending them rote questionnaires that have meaningless answers.
And actually, we want to avoid any situation where that de-risking actually has negative impacts on migrant workers who are seeking better livelihoods, seeking to support families, achieve their goals, and that's ultimately what we would hope to be achieving. Maria Isabel, can I ask you to comment also on how you see the regulations encouraging or discouraging collaboration between private sector and government?
Sure. I think there's fear, and that's maybe the biggest barrier to collaboration. Fear from the legal teams about the risk of litigation increasing as a consequence of the regulation, which is partly true and not. I always see, being based in France and seeing how the duty of vigilance law has turned out, the litigation is just the tip of the iceberg. There's so much underneath of what can be done and can be addressed, and so we need to put our teams together, legal, procurement, sustainability, around the table, and everyone having a similar voice of a similar weight, because each team knows, procurement knows the supply chain, sustainability knows what worked and what hasn't worked, and the legals will know the legislation. But so I would really encourage those chief sustainability officers, to sort of push back on how you're held back from that legislative, very legalistic approach, because the CSDDD does, through the adequate measures, give you that, can be seen as uncertainty by the lawyers, but also that capacity and flexibility to act and reflect on what's really going to have an impact. And so I think I agree with Ray. It encourages collaboration to a certain extent, and it encourages collaboration not only within business, but also across governments. I think one of the key important articles is the one that talks about cooperation and the need for member states to ensure that they are cooperating with countries outside the European Union to make this possible. And here's where, going back to Malaysia, sitting around the table, we say, okay, we say that through human rights due diligence, we can create shared value for all. Yeah. Let's show that we are all investing in it. And how, how will Malaysia do it? How will the EU support those efforts? And how will business bring things back to the table? And I also think there's one thing that was mentioned yesterday about antitrust law and trade secrets law as some of the potential barriers to collaboration. And I think to some extent CSDDD does grounds all the progress that has been made in terms of collaboration in that pre-competitive space, and set some antitrust will always be the guardrails of where we need to operate, but it does set I would say embed the fact that we need and have to collaborate in this space for it to be successful. So I think that's reassuring anyway.
That's brilliant. Bart, can I ask you to comment on that, sort of many of those points there, collaboration between EU member states and source country governments, producing governments, the antitrust question, and the fear of litigation, and whether you think this is driving more collaboration or less collaboration?
So I think that when we talk about CSDDD specifically, and then with it probably most of the other laws that are being mentioned here, that what they create is for us really what we call an actual impossibility not to collaborate, because just the sheer extent and the burden of what is being required means that no one company can do this individually, whether we talk about deploying grievance mechanisms, stakeholder engagement at the scale that CSDDD requires, or whether we talk about, addressing root causes such as, diverging local policies and producing counter needs. There's literally now, because of this law, an impossibility not to collaborate, because doing this in the collective is clearly the only way to get there. Now, of course, whether the legal regime or the key laws incentivize this is difficult to say. I think personally that it's safe to say that CSDDD incentivizes the right behaviors that can drive impact. Ultimately, whether companies will comply with CSDDD in a way that makes it a meaningless and impactless check the box exercise, or an opportunity to deliver and to scale impactful due diligence is largely going to be determined by their own mindset and their own choices. But I do think that by design, what CSDDD mandates companies to do is the right thing, is things that drive impact. And the same applies to collaboration. If you look at the design of CSDDD, I genuinely believe that it does the right thing. That's also why we as RBA stood up and championed on industry side support for adopting the final version of CSDDD. It's an incredible, ambitious law, but it is, in our view, well designed also when it comes to collaboration. So first of all, CSDDD clearly mandates that companies can use industry initiative, multi-stakeholder initiatives, industry schemes to implement key requirements. Then within specific articles like remediation, like grievance mechanism, like stakeholder engagement, the CSDDD again specifically tells companies what's being asked is a lot, but you can do this in the collective. And then even going further and setting sanctions, CSDDD and EFLR as well mandate that the setting of the sanctions should happen by looking and by considering at whether companies have engaged in collective efforts, including for remediation. So something very important when we talk about remediation. So I think by design, very clearly, those laws, contrary to some of the existing laws on the book, do incentivize the right thing. Then, of course, how companies decide to act on this is to be seen in the future. I just want to also mention that when we, for example, ask our membership, is a law like CSDDD gonna make your work, including in the forced labor space, easier or not? We clearly see that 90% of the sustainability leaders in our member companies, and they're the biggest companies in the world, say that those laws will make their life easier. They come with huge burden. There may be inefficiencies from the fact that there are divergences, but laws like CSDDD specifically are recognized as drivers that want to make the sustainability work of companies easier. Now, that's for collaboration between companies, collaboration with governments. That's where I think that as much as RBA has been championing the adoption of CSDDD, has formally stepped up in favor of the adoption of CSDDD to show that there was industry support. That's perhaps one of the areas where we do recognize that the EU hasn't been doing enough. So I think clearly engaging with governments in producing countries has been insufficient throughout CSDDD negotiations. Whether that has impacts on the design is something that I don't have an official formal position on, but I think that speaks for itself. So I think it's clearly recognized to be an area where now going forward the EU needs to step up the game, and we as RBA actually already started addressing that. So we're now in collaboration with the EU External Action Service, to go into key producing countries, the priority countries from where our industries import most into the EU, to go sit there together in a tripartite manner with industry, with the EU, with local governments, to talk about how are these laws going to impact you and how can we become more collaborative in the way we engage that. I can't say anything as to specific conversations with specific jurisdictions, but just in the past months, we've been doing this in Indonesia, in Malaysia, in Vietnam, in Taipei just last week. And while I will say that the leverage created by those laws in terms of how much concrete policy changes you can drive is very different country by country, because the leverage created by those laws is just not the same when you're in Indonesia versus when you're in Vietnam. There is, I think, a clear awareness from local governments that changes will need to happen for those countries to preserve the attractiveness of the country for the industries that operate there now that the new laws kick in. So I'm optimistic about the positive potential of these laws to drive more collaboration, both within industry, but also between governments and industry.
Great, thank you, Bart. And it's true that there's always this request from the private sector to have that harmonization, which is a wonderful goal, but it's also going to be very challenging. I want to sort of talk about the risks also, the perceived risk from the private sector, and how we can really be sort of face the challenges of what this means and how this is impacting the motivation of companies to come forward and sort of talk about the issues that they're facing in light of this new landscape. Would any of you want to sort of reflect on what the perceived risks are from the private sector, and how we can maybe encourage that continued collaboration even as these laws come into force?
Well, I think there definitely is perceived risk, and I think if you are a lawyer passing through the CSDDD, there's plenty of legal uncertainty in there, and there is plenty of potential risk on the face of it when you look at the increased disclosure expectations and the diligence processes that will necessarily have to be gone through and documented and retained, and then potentially subject to disclosure, and the expanded opportunities for complaints and then enforcement. And so I think there's probably a divide between leaders in this space who have been working with this for a long time, and those who may not have started or are in the early stages or have taken a very sort of compliance technical approach to things. Because with more information out there, depending on what the information is, there's always going to be a risk of complaints and potential litigation. I think companies who are leading and who have the confidence in the way they're going about that recognize that you may be challenged, but if you have confidence that you can justify your processes in the way in which you've set them up and you operate them and the outcomes, then you're in a better position, obviously, to meet that if and when it happens. I think there's But there is a lot of uncertainty around this, and I think there is this need for dialogue within many companies, which hasn't happened effectively to date, partly because it just hasn't been a mandatory issue, is how do you explain to your lawyers exactly what you're trying to achieve, etc., and then come up with solutions that work, that identify and deal with the human rights risk, while at the same time, very legitimately, dealing with the risks to the company that might be entailed, and being aware of what those are, but then, hopefully you're able to navigate and manage those. I think there's a big obligation, obviously, on supervisory authorities and the enforcement. I think Norway is probably a good example, where they have a sort of principles-based approach under the OECD guidelines to their due diligence law, and the authorities there seem to have taken a very sort of open approach to talking to companies about what the expectations are, the challenges they're meeting. And obviously this is going to be challenging for many people for a long time. At the same time, given how long it's going to be before this is transposed into member state law, but then quite quickly, coming into effect for some companies, really starting to be, getting on with it, but being confident that there will be realistic expectations and a harmonized approach and coordination between the authorities as to, how to supervise and then enforce, and what's needed to support companies, which I think is, is there in the directive, but delivering it in practice is going to be another challenge. And then I think from civil society, obviously important to, hold companies to account, and there's a lot of cynicism in some quarters. But I think, having a strategic approach to any complaints or litigation is really important, because it is having a very negative effect in some jurisdictions. And so there's this sort of, why are we litigating? What are we trying to achieve? Is this actually going to make a difference? Or are we're actually going to just drive companies, back behind the wall? So I think there's a sort of shared responsibility, and obviously there's plenty of examples of civil society working with companies, obviously, to make improvements in this space. So I think it's enlightenment, understanding what this really is, and trying to make effective outcomes. And as I say, businesses in particular having and being allowed to have the confidence to try and make effective change.
That's brilliant. I love that shared responsibility to ensure that we can continue to collaborate in the midst of the new landscape. Maria?
I really see this in the space of CGF Human Rights Coalition, this very big appetite from our members to have a different way of engaging with their right holders and their stakeholders that is over time, that is sustainable, that is continuous, and not just one-shot engagement. And I think this is really going in that direction of a shared responsibility, of a willingness to address the issues properly, rather than just protect yourself. I think I really like this that you said, Ray, about explain your lawyers what you're trying to do. I think that's the right approach when I was saying, let's sit all around the table and talk about the issues very frankly. I think there's the risk would be to put the lawyers only in the driver's seat, because everyone's no offense. I'm a lawyer too. But yeah, we all have a different piece of of how we do business, and we need that comprehensive understanding of the business and the risks and the places where you are operating to be able to do the due diligence right. So I really think, that interconnection that I spoke to about the government is also true at the level of the companies. We are working at CGF to making sure we break those walls as part of making due diligence work and connect the people across functions, because the due diligence is something that needs to be mainstream and embedded across the business. And I would say one of the other perceived risks is about transparency. Yeah. How do we prevent this wave of legislations pushing back on transparency in companies? And I think we really need to show, probably through examples, how transparency is not an opposite, in a balance against litigation. I don't think more transparency will necessarily lead to more litigation. Yes, you're putting yourself out there when you reveal your supply chain, for instance, but you're also opening the door to collaboration. Yeah. Antitrust cannot get on your way if you are open about your supply chain, because once information is in the public domain, then we'll be able to collaborate. And I will certainly give a hard time to our members on this topic in the coming years, because if we are honestly trying to put our heads together to work towards a common goal, that's necessarily part of the equation. And then the second thing is, I think, and this is why the value of CGF is very important, we are a CEO-driven organization. And so our Human Rights Coalition is sponsored by two CEOs, the CEO of Lipton Teas and Infusions, Natalie Ross, and the CEO of a retail, IGA, John Ross. And they are bringing the ambition and the messages of the Human Rights Coalition to the CEO level. And I think this is key, because here, when we're talking about due diligence and when we're talking about where our company is going to put the resources when implementing their due diligence, this should be a top leadership decision about the business model. Is our business going to invest in preventing risks, in paying for, the preventing the litigation, ticking the boxes, or is our company going to continue investing on those pilots that worked well and that provided outcomes? And so I think the balance, rather than transparency versus litigation risk, is about, outcome-driven HRDD versus a process-driven HRDD. And you do need a process, but you should not get lost in it. Remember, your business model, and I think that's what the top leadership should be looking at, is let's put our investment in those actions that are showing positive outcomes, because that's how we can make sure that we're investing in the adequate measures and we're making our business sustainably more sustainable.
That's brilliant. And I love what you said about making sure we have leadership buy-in to achieve impact and not taking steps backwards on the transparency. Bart, you're a lawyer too. Can I invite you to also comment on the potential risks of collaboration, how that's perceived, and then we'll go to questions. Apologies, I think we're...
I feel like saying I'm a lawyer is the entry ticket here into getting the floor. So yes, I'm also a lawyer. I try to hide it, but a human rights lawyer, not a competition lawyer. But I do want to comment just on the antitrust dimension, because it's an extremely important one, as the fellow panelists have highlighted. And again, I'm not a competition lawyer, don't pretend to understand all the technicalities of this, but what I do think is important to flag that this is very much on the mind of the EU regulator, and a solution has already been adopted actually last year before even CSDD was adopted. So there are now updated EU horizontal guidelines on antitrust rules and guidances where actually this situation was foreseen, and the updated EU horizontal guidelines now explicitly clarify that antitrust rules, EU antitrust rules that is, do not stand in the way of agreements between competitors in the space of pursuing sustainability objectives. Those guidelines actually even now explicitly provide a safe harbor for standardization agreements, for example, for industries coming together around code of conduct for sustainability endeavors. So that includes sustainability due diligence. So while I'm not a competition lawyer, can't judge whether those solutions are enough. And of course, I can't predict what their global impact will have specifically within EU jurisdiction. I do think that this is an issue that is being addressed, and through horizontal guidelines like that are now being resolved. But I'd be interested in getting further lawyers' advice on that. On the other risk of, like the laws incentivizing, and it's no doubt, I agree with the panelists, the biggest risk, incentivizing more process oriented focus than outcome based. That's what I think the liabilities are so important. Mandating due diligence, mandatory due diligence, indeed in itself could lead to process oriented efforts, but by attaching liabilities to it, you actually make sure that companies have an actual stake in the quality and the reliability and the integrity of their due diligence. That's why now, even if it was not in the law, fortunately it is, but even if it was not, our member companies would have committed voluntarily to things like upholding quality criteria for industry schemes, quality criteria for independent audits, because without that, you can't assure the quality, the integrity, the reliability of your due diligence. You risk liabilities, and I think that threat of liabilities being attached to the failure of due diligence outcomes is most of what we need, not all we need, but most of what we need to make sure that those due diligence efforts in the future, way more than today, become impact oriented and not just process oriented.
That's great. Thank you, Bart. And we have 6 minutes for questions. Apologies, Bonnie.
So there were a lot of questions on the CSDDD. I'm going to group them in one round. There are a lot of lawyers on the panel, so I'm not going to come back. So there's a lot of questions around how we can meaningfully do peer collaboration. CSDDD has a provision on companies collaborating to increase their leverage. But there were a lot of questions on how we can do this meaningfully, considering that there are antitrust concerns. We have questions asking, is there any authoritative text that gives companies that want to do this guidance on navigating conflict of laws and different bodies of law? So a lot of questions to get law students' heart pumping. And then we focus a lot on Norway. Norway, CSDDD, the French law came up. But what about some other legislations, that you can comment on? And then lastly, a very interesting question on, does the CSDDD, can it increase better collection of data on forced labor? What do you see as the potential in that? Thank you.
Brilliant. Very meaty questions there. Ray, can I ask you to start on meaningful peer collaboration? What is the guidance on conflict of laws, and talk about other jurisdictions as well that we haven't mentioned today?
Sure. On competition laws, that's not my area, but obviously you should have legal advice, and unfortunately, I suppose, so far, I think the EU is alone in having created this exemption for certain types of agreements in the sustainability space, insofar as human rights issues are concerned. So obviously you'd have to be mindful of that in multiple jurisdictions. The difficulty with conflicts of laws is you almost certainly have to comply with all you will have to comply with all laws that apply to you. So navigating conflicts can be really difficult. I mean, nowhere more so than, in relation to trade issues and sanctions, for example. And you've got a lot of that happening right now with obviously the differences between, the United States and China, and how to do due diligence in relation to Xinjiang, for example. So unfortunately for companies, you just have to make sure you're in compliance wherever you're operating and the laws apply to you. And it's not easy sometimes, and you have to make really difficult choices.
Maria Isabel.
The conflict of laws point could be like a whole class on international law. I would say that, regulations have come in similar directions on the corruption field, on, anti-bribery legislation, on food safety, and, pushing companies globally to change the ways they operate and to understand the global landscape legally. So I think most companies, the bigger ones, certainly in the room, have the capacity to figure this out. We can figure it out together. I just think we need to know where we want to go before we dive into the legislations, because I think lawyers have the power to make out of these legislations many things. And so we can navigate this complex environment, and the outcome will be positive if we know from the start where we want to be. We want to be in a space where we can collaborate, we can actually solve issues where we have a positive impact and are not only focused on process or reporting. That's where we want to go. Now, let's bring our lawyers to the table. How do we make this happen? How do we understand the tools that we have and the limitations? And so I'm quite positive about how the outcomes are. The future is looking bright, but definitely collaborating. We've collaborated with legal clinics in different universities in different countries, and I think this is part of interesting initiatives that can help companies and groups of companies increase their capacity to understand law, and to also bring young leaders into this space of reflecting about what are we going to make out of these legislations. And in terms of data collection, I think CSDDD may be less than the forced labor regulation. I think the forced labor regulation has more of that intent and power to collect data and make data available about recruitment corridors and risky products and groups of products and geographies. So I see the data points more there. We need to figure out how to make that data sharing collaboration also work under CSDDD.
Bart, in the last minute. Sorry, Bart, just start again.
Yeah,
You're
thank you. And then if just in 1 minute, I just have to pick one, so perhaps the conflict of law topic. I think for our members, that takes two very practical dimensions. One is conflict between EU due diligence laws that apply to them, for example, between CSDDD and the existing EU batteries regulation. Our member companies operate in spaces like the battery space, where there's already sector-specific law. The other dimension is conflict between CSDDD and laws in producing countries, whether it's anti-espionage law, trade and IP law, or diverging substantial standards, for example, on recruitment fees. Those are two different dimensions on which I think it's safe to say that the EU regulator anticipated the issue but didn't properly fix it. What I mean by that is, on the conflict between EU cross-sectoral and sector-specific law, the EU has theoretically solved this by writing into CSDDD that the most stringent rules will take priority, but that doesn't resolve the real challenge, which is that companies active in the same space, depending on whether they're subject to CSDDD or not, will have to follow different rules for the same supply chains being active in the same industry, which is, I think, unacceptable from a political point of view, but which is the reality, despite theoretically there being a solution written in the law. For the other dimension, the conflict with law in producing countries, same thing. The EU regulator has thought of this, has written this in the law. EU CSDDD specifically mandates that the Commission will develop guidance to address the situation of how companies can uphold their CSDDD requirements while being in compliance with trade law in producing countries. But again, we know that European Commission guidance in itself is unlikely to resolve that practical, real challenge for companies. So has been thought of, but I don't think has been properly solved. And yeah, I think it's one of the key challenges to collectively work towards between industry initiatives and law firms going forward.
Thank you so much, Bart. A lot still to be figured out, I think, is our conclusion. Lots of opportunities, potential for collaboration, lots of risks to be aware of at the same time, and a lot more to talk about than we had in 1 hour. But please join me in thanking our panelists for such a great